of the committee is. And then we will open this up for discussion. We have 2 hours and Tunde and myself will not speak for too long because we want to hear from the Nigerian Arbitration Community. And can I just say that it goes beyond Nigeria. Nigeria is a major player when it comes to international arbitration. And so we do have people who have signed up from across the world, which shows how important this particular issue is to people in the industry. So I'm going to, therefore, just the agenda for the day, I'm going to introduce or ask Tunde to introduce himself. I usually prefer that people introduce themselves because they can tell you what they want to tell you and the one they don't want to tell you, they won't have to tell you. So I'm going to ask Tunde to introduce himself. And then I would also ask Olisa so that I don't have to get him to introduce himself much later. You all know him. I didn't know he was called Presido, by the way. I just recently found out that he is Presido. So I'm going to ask Presido as well to please kindly introduce himself. And then I would then reel out how we would proceed. We also have some polls, as you can imagine, because it's important that we understand where colleagues are on this and what their thoughts are as well. So I'm going to ask Tunde to please introduce himself. Tunde.
Thank you, Emilia. And hello, everyone. It's good to be here today. I'm honored to have been invited to have this discussion with Emilia, who I have immense respect for. Well, just before I introduce myself, I should mention the clue to Presido, Emilia, is that I've known Olisa in 2 presidential capacities. When I joined him in 1989, he was my president in CLO, and then he's also been my president as a president of the Nigerian Bar Association. So you would understand why I fondly call him Presido. Right, now I'm Tunde Fagbonlu, and I am the head of disputes practice in Aluko and Oyebode, one of Nigeria's foremost commercial law firms. In addition to that role, I also currently chair the board of directors of the Lagos Chamber of Commerce International Arbitration Center. So I am involved with arbitration in quite a number of capacities. In almost every capacity you can think of, running an institution, sitting as arbitrator, and also acting as counsel in arbitrations. And these are both domestic and international arbitrations. Thank you very much, Emilia.
Thank you, Tunde. Olisa, please.
Okay, as you say, my name is Olisa Abakoba. I am a member of the Olisa Abakoba Legal Arbitration Law Practice, and I've had a passion for how arbitration can be properly conducted, and in particular how Nigeria can, play a greater role. And as you know, Emilia, I'm a member of the African Arbitration Association. In our last meeting in Kigali, we talked about the inclusion and inclusiveness of Africans in the whole arbitration space. So I'm a member, I'm very proud to be a member of the advocacy committee of the AAA, and I'm happy we also now have a pledge, which is all about how do we, Africans, Nigerians, get to occupy more space in the, in arbitral work around the world. So I'm very happy that this discussion today will, lend the voice to how best, I think we'll agree, how best can this be achieved. As Emilia said, I've just been recently appointed to chair the Arbitration Policy Committee, which is why I apologize that I had to recuse from debating with Tunde. I would have loved to give him a whooping. but now I'll come back on when Emilia invites me to throw more light on or give information. Thank you, Emilia. Thank you.
Thank you very much, Olisa. Thank you, Tunde, for those introductions. As colleagues can see, we're all colleagues. The 3 of us actually belong to the African Arbitration Association. And for those of you who don't know me very well or know about my work on arbitration, I do research, I teach, and I also practice as an arbitrator. But unlike Tunde and Olisa, I don't act as counsel anymore. I used to do that in the past, but I don't do that anymore. Again, just no time. Okay, so the key thing we want to do is I want to just sort of at the outset, on the 13th of October, an online news outlet called the NigerianLawyer.com. I want to just read out a bit for you what they said, because they were the ones who then told us that we now have this committee on the National Arbitration Policy. So I'm going to read out that because it sets out the vision of the Federal Attorney General on the question of a national arbitration policy. So I'll read that out. We will then have our first poll, okay? And so the first poll will come up shortly. And Stephanie, can I ask you to please put up the poll while I'm reading so that our colleagues can start looking at that. So what they had, so the NigerianLawyer.com, I'm quoting now, so I have to read, they said, Attorney General of the Federation and Minister of Justice, Abubakar Malami, SAN, has charged the newly inaugurated members of the National Arbitration Policy Committee to come out with a comprehensive policy that will, among other things, ensure that domestic transactions originating and terminating in Nigeria are arbitrated in the country being Nigeria. According to the minister, the objectives of the proposed policy include protecting Nigeria's economy, ensuring that transactions originating and terminating in Nigeria are arbitrated in Nigeria. Other objectives were having the seats and venues of arbitrations in Nigeria, thereby creating jobs for and maximally harnessing the talents of Nigerian lawyers who are specialized in arbitration, as well as saving the country billions of dollars. So that's what the NigerianLawyer.com published on the 13th of October 2020. And so our first poll, we felt that we want to know what the community, what you think. So the first question is, should Nigeria adopt a national arbitration policy to promote the involvement of Nigerian practitioners in arbitration, and B, avoid outcomes such as that in the P&ID case? Okay, so it's a yes or a no. Basically, should Nigeria adopt a national policy on arbitration? I think you can vote now, and we will give you 30 seconds to do the voting. And the 30 seconds will end. Stephanie, just tell me when 30 seconds is up, or just remove the poll and let us know what the result is. Okay, great. So Stephanie, please, what is the result of the poll? Because that would be very helpful. Let's know what the community think. That's very impressive. So 81% think that Nigeria should have a national arbitration policy. Okay, great. Stephanie, please, can you close the poll for us? Thank you. That's a huge percentage of those attending the webinar. And so one of the things we want to do, as you can imagine, as an academic, one of the first things I did was, when I was asked to moderate, is how many countries actually have a national, an articulated national policy on arbitration that is published, that sets out that vision of the state. It was quite difficult to find any that is clearly articulated. So in the UK, the courts, so again, the UK courts, the English courts have a clear public policy to support arbitration. And so we're going to bring a comparative view to our discussions this morning on how they have articulated their own clear policy and how they are implementing that going forward. And so one of the things that from what I have read, from what the Attorney General had set out, what it looks like is that the national policy on arbitration wants to develop Nigerian arbitration practitioners, either as arbitrators or as counsel, tribunal secretary, whatever, to develop arbitration centers and institutions that we have in Nigeria, and we do have quite a few, to unpack the lessons that the country has learned from P&ID and the several other arbitration matters, international arbitration matters currently going on against Nigeria, awards that have been made against Nigeria, and Nigeria's participation and engagement. And I think that is really important, that the Federal Ministry of Justice and all the other ministries that are implicated, including NMPC, DPR, and all the Ds, that we need to understand their engagement with arbitration, their engagement with international contracts that they sign up to, so that we know where the gaps are. We do not want our country to be known as a place wherein they sign a contract and they don't comply with that contract and they do whatever they want. And when they participate in arbitration, you get an award and you can't enforce it against them. That's a terrible reputation to have. But that is the current reputation that Nigeria enjoys, unfortunately, internationally. And so we're going to also look at that to see how we can remedy some of those issues. If we have people on the call who have not read P&ID, we're not going to rehash P&ID. So it's useful that you can just quickly Google it. You'll find loads of summaries that you can quickly read if you want. But we're going to assume that everybody knows about P&ID. And so when we're talking about policy options, we would be thinking of, should we then go for a mandatory option, or should we make it non-mandatory so that it falls within party autonomy? Or is it the states that can then determine this is what you must do, or this is what we suggest that you do? And so that's the major context that Tunde is going to explore some of the issues and questions that I'm going to ask him. And then we also recognize that there are different forms of commercial transactions and there are different parties. So that you may just have a commercial transaction that is completely between two private Nigerian companies or Nigerian entities that does not have any public policy implications, that does not have any outside Nigeria or international implication. So if you like, we can call those pure domestic or private domestic, howsoever Tunde and Olisa decide to name them. But we know that we have those. Then we have transactions that are between Nigerian companies or corporations and foreign entities. But that's still completely private. That does not implicate the government or the public space in any shape or form. And then we have those contracts that the Nigerian state or Nigerian agencies, so public body agencies, so that spend our tax money or our oil money, Nigerian public agencies, that the transactions they enter into, whether with a Nigerian company or a foreign company. Then we have those where either we've signed bilateral investment treaties with other states. I'm sure you are all aware that Nigeria has a couple of those treaties out there with foreign companies where we want to attract foreign investment. The Buhari administration, through the vice president, has always said, oh, we want more investments. We're a good destination for foreign investors to come to. And so we do have quite a number of foreign investors engaging in Nigeria, reliant on the efficacy of these bilateral investment treaties and promises that the Nigerian state is made in the NIPC Act, for example. And so the key question then becomes, what also would happen in that space. And so you can see that is a little bit complex, and there's a lot of intersections between the various regimes. And so my job is to sort of set out for us the context of this discussion. And so the way I love to summarize P&ID is that you invest, and that was before the latest decision and the investigations by EFCC. So I must give a clear shout out to EFCC. I must say a huge thank you to the US courts for allowing Nigeria to trace some of those, to get information from the banks. Otherwise, the way we would describe P&ID is you invest 40 million, after 2 years, you get 9.6 billion. It doesn't happen anywhere. It makes no sense. You can't square that. And that has, brought out a lot of interest. I don't know whether good interest or bad interest for arbitration in Nigeria, but that's what's led us to this point. So I'm going to ask Tunde. Tunde, do you want to just sort of recap for us? And I've set out the 4 scenarios. I've talked about the need, should we go for a mandatory? Should we go for soft law? How should we? So we can balance party autonomy and the interest of the state. So I'm going to ask you to please kick off the discussions for us.
Thank you. Thank you very much, Amelia. And, I guess what I'd like to do is to preface what I'm going to say with this. It's an analogy. It might somewhat drive the point I'm going to be making home more forcefully to start with this analogy. And I'm going to borrow this analogy from the medical sciences. We all know the distinction between ailment and symptom, right? And let's take a very simple kind of ailment, malaria. We know that malaria is an ailment that comes with symptoms. One of those symptoms is aches and headaches and all whatnot. Now, you use paracetamol for the symptoms, for the rising temperature and the headaches, but that does not cure the ailment, right? The ailment will continue if you restricted your therapy to just dealing with the headaches and the fever. You need to use a malaria drug to get rid of the underlying cause, the ailment itself. Now, you don't do either one in isolation of the other. So you don't treat the ailment without also taking care of the symptoms. And you also don't take care of the symptoms without taking care of the ailment. And I think that's the kind of situation that we find ourselves in Nigeria. When I look at the P&ID case, or indeed when I look at the other reason why a policy is being advanced, which is that we need to promote Nigeria as a seat, and we need to promote Nigerian practitioners, all of which I completely agree with. I'm a Pan-Africanist, and I absolutely will do anything. I will be part of anything that's going to advance Africans in general and Nigerians in particular. But what I will not do is support a policy that I think might be aimed at merely taking care of the symptoms and ignoring the ailment. And that's why the kind of discussion we're having today is very important, because we need to be able, and Emily, I love the way you dissected the various issues just now, the way you disassembled them into their specifics, because I think any kind of analysis is greatly assisted by unpacking the issue into its various components and dealing with each component one by one. And that's the approach I'm going to take. And the components you had discussed just now, you talked about private domestic, you talked about public domestic, and then you also then talked about the international versions of those two distinctions, private and public. And I'm going to follow the same order. Now, let's start with private domestic. And private domestic essentially refers to that situation where you have two parties who are purely Nigerian and are not governmental. So the fact that they are purely Nigerian is what makes it domestic. And the fact that they are not governmental is what makes it private, not public. And that's what I'm going to start with. Now, do you need a policy for that situation? Now again, before I begin to analyze that particular scenario, let's talk about the policy itself. From what I can glean from the Honorable Attorney General's statement, as you read it out from the online newspaper publication, and I hope, of course, that he has been accurately represented by that online newspaper publication. But if he's been accurately represented, it's clear that the intention of the policy is to achieve two things: save Nigeria's economy, which I completely support, and also advance arbitration practitioners, which again I completely support. Now, there are many ways in which you can achieve that objective. What I'm going to do is to state two extremes. And in between those two extremes, you have a spectrum of possibilities, different policy options. One extreme will be to make it mandatory with legislation that in future, all arbitrations concerning Nigeria must be held in Nigeria, and only Nigerian arbitrators must be appointed. So that's one extreme. At the other end of the spectrum will be no legislation, just a collection of policies, guidelines, soft law, incentives. Basically, don't oblige people to do anything, but encourage people to do things, and then put an enabling environment in place. So that's the other end of the spectrum. And in between those 2 points, there are different types of choices, policy choices that you can take. Maybe a mix of legislation and a mix of soft law. Now, so having identified the various policy choices that there are, let's look at each one of the examples you gave us now, Emilia. And I'm starting with private domestic. Now, the first question that comes to my mind when I consider private domestic is, what's the need? Why do we even need a policy there at all? I think the two objectives of the policy are already being achieved in practice. And this is what I mean by that. In cases that involve purely Nigerians and that don't involve the government at all, I have hardly come across, in my many years of practicing as an arbitrator, either as arbitrator or as counsel, I have hardly come across any cases in which purely domestic Nigerian parties that are not governmental have chosen a foreign seat to arbitrate. I have hardly come across it. They might choose an international institution like the ICC or the LCIA, but they typically tend to choose Nigerian seats, and they typically tend to appoint Nigerian arbitrators. Okay, so I'm not quite sure that private domestic presents any policy concerns of the type that have motivated the need for a Nigerian policy. Let's then move to public domestic. And in public domestic, of course, again, you have only purely Nigerians, but one of those parties, whether claimant or respondent, is a governmental entity, whether of the federal government or a state government. One of them is a government, and that's what introduces the public element. Now, again, from my experience, hardly do I find parties choosing a foreign seat. I've done quite a number of production sharing contract arbitrations involving the NNPC, a governmental entity, and international oil companies. And all of those arbitrations were done under model production sharing contracts that choose Nigeria, a place in Nigeria as the seat. Now, the only difference, of course, is that, the production sharing contract will not be a very good example, because I need to make a point. While I said just now, domestic means purely Nigerians. Now, we need to emphasize something. Purely Nigerians would not include companies that are Nigerian vehicles for foreign investors. We all know that under Section 54 of CAMA, the Companies Allied Matters Act, any foreign investor who wants to do business in Nigeria must incorporate as a Nigerian entity. And you typically find that those companies, they may be 100% owned by foreign interests, right? But they are Nigerian incorporated companies. That does not make them qualify for domestic, because in essence, they are foreign investors. I will exclude those from the definition of domestic, right? So I'm talking only about those companies that are owned and controlled by Nigerians, whether fully owned or majority owned. Nigerians, only Nigerians. Now, in those types of situations, again, I hardly come across examples where the parties, one is a governmental entity, the other party is a fully owned and controlled or majority owned and controlled Nigerian company. I've hardly come across situations where they choose a foreign seat. Again, they typically tend to choose Nigeria and typically tends to appoint Nigerian arbitrators. Okay, so now the only situation in which I could envisage a fully owned or majority owned and controlled Nigerian company wanting to choose a foreign seat where their contractual counterparty is the government is where the owners are probably apprehensive that in the event they need to enforce an award, or in the event they get a favorable award against the government, they may find it difficult enforcing such an award through the Nigerian courts because they have.
Tunde, can I interrupt you a little bit?
Yes,
indeed. So before we move on to the where you have a government agency or where the public gets involved, yes, I would want you to speak a little bit on where you have purely domestic, because yes, there's some of those that the parties would either come to London, primarily London, 6 hours or 5 hours away, depending on whether you're in Lagos or Abuja. Some of them would come to London to host, to have that arbitration. And some of them would actually choose a London seat. The vast majority, is usually a London seat. And so because I wouldn't want people to go away thinking that all purely private domestic, we don't ever get those who want to come, who have a foreign seat. We do have a number of those. So I would want you to sort of speak a little bit. What's your view? Do you think that as it relates to those particular types where it's purely private, purely domestic, should the national policy require such parties to ensure that such an arbitration happens only in Nigeria? So should the Nigerian government or the Nigerian state curtail the autonomy of the parties to choose a seat that they want and say, it must happen in Nigeria? As long as it's purely domestic, it must happen in Nigeria. What's
very well? Thanks for bringing me back to that, Emilia. I guess my disposition on that particular subject had been informed by my own experience, which really is that, again, I hope that in the examples you mentioned, Emilia, indeed, those companies were in fact fully or majority Nigerian owned. Now, assuming there was such, and I don't claim to have represented everyone that fall within that category. I only say that the ones I have experienced, you tend to find that those companies have significant foreign interests, and that's why a foreign jurisdiction or seat was chosen. But yes, I totally agree with you, Emilia, that, let me make this confession right away. I mentioned the spectrum just now. At one end of the spectrum, mandatory legislation obliging people and therefore curtailing autonomy. At the other end of the spectrum, creating an enabling environment, encouraging and giving incentives, but not obliging people to do anything. I definitely incline more towards the laissez-faire end of the spectrum, which is let parties have as much autonomy as possible. Government has no business interfering in the space of contract, except there's a major public policy issue involved. Government, of course, can intervene through statutes to regulate contractual relationships where major issues of public policy are involved. But as I'm going to show you very soon, the P&IDL problems reflect more fundamental weaknesses with with our system.
Okay, before you move again, I would want us to just sort of wrap up on what the view is. So I think that from what you have said, and from what I'm hearing, what you're saying is that where the transaction is purely domestic, purely private, so no, it does not engage any government agency or government or public interest, that party autonomy should rule. People should have the freedom to determine where they want the arbitration, what sort of arbitration they want, and they should have who they wish to appoint. They should have that freedom.
Correct, Emilia, correct. Absolutely.
Okay.
That's the comment I'm making,
Okay,
yes.
perfect. Okay, so it's just so that we're clear, we know what your view is, and then so we can check off on that one. Please carry on.
My preference would be for let us tend more towards party autonomy than towards limiting people's choices by legislation.
Okay.
So now go to it's pretty much the same with public domestic, and I can see a stronger motive for wanting to choose a foreign seat, even where the counterparty to the government is a purely Nigerian-owned or controlled seat, and that motive will be apprehension that a significant award against the government may find it difficult to survive an application to set aside in a Nigerian court. That raises, of course, questions about independence of the judges. And when I say that, of course, I must say right away that I have come across, I have experienced judges who are able to assert independence when dealing with litigation between private companies and governmental entities. I'm not saying that we don't have such judges, but we also do have judges who have shown a tendency to always decide in favor of government. We have that as well. So it's a mix. It's a bit of a gamble. And for that reason, to avoid that gamble, a fully owned Nigerian entity may prefer to choose a foreign seat in which they have a lot more confidence about the independence of the judges. Okay, so that's what may motivate a private company having a governmental counterparty to want to choose a foreign seat, right? Everything I'm saying will, ultimately conclude in my own recommendations as to what the contents of a national policy should be. So you would have deduced from what I said just now that I am not opposed to a national policy. The question is, what should the contents of that national policy be? And that's what I'm going to conclude with. Let's go to the second, the third example in the list of 4 examples we gave, Emilia, and that is international private. Now that becomes more interesting because it's in the scope of international private and international public that you begin to see people definitely expressing a preference to have foreign seats as opposed to Nigerian seats. Many of the contracts, of course, I mentioned the production sharing contracts just now in the oil and gas sector, where Nigerian entities that are fully owned or controlled by foreign investors nevertheless agree to have arbitrations in Nigeria. But when you look at the composition of those panels, you would find that it typically tends to have a majority of non-Nigerians. And the Nigerian government entity would typically appoint a Nigerian, right? So even though at the contracting stage, the foreign interest may have chosen a Nigerian seat, when it comes to appointing arbitrators, you tend to see that they prefer to appoint non-Nigerians. And you obviously have to ask yourself the question, why is that the case, right? Now, but in the majority of other contracts, particularly the ones that take place between private entities, in a countless number of them, it's almost the exception for you to find them choosing Nigeria as the seat. What is more typical is that you would find a New York or a London or a Paris seat. And again, you have to ask yourself the question, why? Now, we have to ask ourselves very hard and honest questions. Do we run a judicial system that the international community can be confident about? That's the question, because when you're talking about seats, that's the major issue. involved in choosing a seat. It's not wanting to go and shop in Harrods or Selfridges that makes people choose London as their seat. It's the fact that the English judicial system has over centuries established a reputation, global reputation, of being a place to which you can come and you can be confident that you will get efficient and effective justice. Now, do we run that kind of system? Do we run that kind of judicial system in Nigeria? I would like to quote an article of yours, Emilia. You would recognize it easily: jurisdictional tensions between domestic courts and arbitral tribunals, which you wrote and published in 2017. And this is what you said: Nigeria is not attracting international arbitrations as seats. It is obvious that apart from a weak non-legal environment, the systemic failures of Nigerian courts create a very weak judicial environment, which is not perceived by arbitration users as supportive of arbitration. These are precisely my views as well. I recently wrote an article in a collection of essays in honor of Tolu Aderemi, International Arbitration from Nigerian Lawyers' Perspective. My article was titled, "Is Nigerian Arbitral Jurisprudence Entering Its Dark Ages?" I was using a historical metaphor, drawing distinctions between the transition from dark ages to middle ages to modernity and post-modernity. And I was talking about how you have this cycle of generation and regeneration. And I was looking at Nigerian jurisprudence on arbitration. Unfortunately, as is reflected in almost every other aspect of our jurisprudence, we have begun to see a backward degenerative trend in Nigerian arbitral jurisprudence. I'll give you an example. Only just this year, a judge of the High Court in Lagos State held that the moment an arbitrator is challenged, that arbitrator must recuse himself. Contrary to the provisions of the Arbitration Act, contrary to the provisions of the ICC rules under which the arbitration was held. That decision shocked the international arbitration community and the Nigerian arbitration community, but it's quite typical of the types of things that we see happen. And I'm not talking yet about the procedural problems, the fact that you could have a case go on for 13 years, end up in the Supreme Court after 13 years before the arbitration itself can start. I'm talking about Luton versus NMPC, where somebody challenged Honorable Justice Uche Omo for saying that he was going to take the evidence of a witness abroad. And so the arbitration was delayed for 11 to 13 years until the Supreme Court finally said, yes, the arbitrator had the authority to make that kind of decision. But that's the kind of judicial system we run. It will be surprising for anyone to say they don't know that that's our judicial system. And if that's the case, then the question is, why do we want to compel foreign investors to submit their awards to that kind of judicial system? So that's the question. And that's why, like I said, we need a policy, but that policy shouldn't be a policy that says compel people. It should be a policy that says create an enabling framework. I'll give you a practical example. When I was appointed to be the chair of the board of LASIAC, the Lagos Chamber of Commerce Arbitration Center in 2014, one of the things that we did was to say we were not just going to run an arbitration center. We are going to create a twin institution that will work along with LASIAC. And that body is the body that's today known as CRID-LawNet. CRID-LawNet stands for Commercial Regulatory Investment Disputes Best Practices. Now, what are we trying to achieve with CRID-LawNet? CRID-LawNet was motivated by the realization that if we are going to promote arbitration in Nigeria, we must also have an enabling environment. We recognize that we did not have an enabling environment. We looked at our civil justice system and we said, there is so much that is wrong with the civil justice. Ulisa and I have worked on this particular issue quite a number of times. We started with something called FOCUS, the Forum of Commercial Court Users, where we recognize that we need to get the users of the court system to take an interest in the way the court operates, right? CRID-LawNet is pretty much a reflection of that same idea. Namely, you need to get the community, the entire business community, to take an interest in revamping the courts. And one of the things that CRID-LawNet has done recently is to come up with a model law on the administration of civil justice, to reform civil justice. We need to reform civil justice. If you have an award in Nigeria, sorry, Amelia, you're going to say something?
Yes, Tunde, I'm going to interrupt you. I have an eye on the clock, as you can imagine. And so yes. I really do want participants to contribute briefly. So I know that I'm going to have to ask some people to contribute. Can I ask you that maybe if you can just for now, use the next 30 seconds to sort of summarize for us what your what your views on the national policy is, just to remind.
Yes, absolutely. So we don't know we don't know the contents of the national policy yet, because Olisa's committee is just going to start working. So what I want to leave everyone with are these views. It's better to have a policy that deals with both the ailment and the symptoms.
Absolutely.
If you have a policy that only says, let us compel people to arbitrate in Nigeria, choose Nigeria as the seat and appoint Nigerian arbitrators, we are dealing only with the symptoms, right? Let's have a policy that says, let us reform our civil justice system. Let us make Nigeria a lot more friendly for both the domestic and the international community. And then let's not force people to do things. Let's make ourselves attractive. Let's not compel people to come to us. Let's attract people to come to us. Those would be my final suggestions.
Perfect. So the key thing, and I'm very pleased, thank you very much, Tunde, for just sort of pulling your thoughts together in those few words. And that is really important, because it's clear in our minds what your views are. And what I've done is a few housekeeping. Please keep your questions coming. Tunde, please start looking at the Q&A. Olisa, I know you've been looking at the Q&A. It's there. Please look at it. Please, you can also use the chat if you prefer, and that's absolutely fine. So before I ask Olisa to say something, we're going to have the second poll, because what Tunde is giving us his own views. What I've also done on the chat, because remember that the policy is looking at more arbitrations happening in Nigeria, and then more Nigerians engaging in arbitration as counsel, arbitrators, tribunal secretary, whatever. And so the Chartered Institute of Arbitrators, and I know they have a very strong following in Nigeria, a few years back came up with the safe seat principles. I must admit immediately, so I've put the link on the chat for people to quickly look at it. And maybe that's something that Olisa and the committee members may want to just sort of see what if there's anything we can take away from that. I admit that as far as I'm concerned, the drafters of the principles were all London-based people, and we have Brexit coming, so it's important to look at where we have strengths and put those there. But they're legitimate principles as well, having said that. The second thing I'm going to say, while Stephanie is preparing the second poll, is that there's a very recent decision that our Supreme Court here made last week on the law that applies to the arbitration agreement, how you identify that law. It's been a vexed issue for us under our own law here. And the Supreme Court, in a fight somewhere towards the end of that judgment, it was a 114 pages judgment, then said, or to just figure out what law applies to the arbitration agreement. But anyway, just then said that it took 7 months from the time that matter was filed at the High Court to get the High Court decision. It went to the Court of Appeal. It was argued at the Court of Appeal. They got the Court of Appeal decision. It went to the Supreme Court. It was argued. So from the time it was filed at the High Court to when they got the decision, this decision of last week, it took 7 months. It took 7 months. And I think that it is something, it says a lot, and Tunde has already referenced that. You can't start an application, you can't start a dispute before the Nigerian courts and hope to get to the stage of substantive hearing in 7 months. You know, you can't do that. And then that is a major problem. And of course, why would the Supreme Court say that? The Supreme Court is saying, come to our jurisdiction and have your arbitration, because we will support your process. We understand that businesses do not have that time to waste. Can you imagine if you had planned a meeting somewhere, maybe in London, before to host on the 16th of, no, we locked down on the 18th of March. So you were planning to come for a meeting here on the 19th of March. And then we went into lockdown on the 18th of March. That's it. So businesses, time is of the essence. And if we do not have a judiciary that understands how they link to the economy, how their role links back to improving the Nigerian economy and jobs for Nigerians, then it's a huge problem. Everything is connected. There's nothing that is in a silo on its own. And so I think those are that's the larger context that we do also need to think about. So I'm going to ask Stephanie, please, can you give us the second poll? Now, the second question would ask, should the principle of party autonomy be reviewed in favor of statutory mandatory legislation to ensure Nigeria is increasingly the seat of domestic arbitration? So we've heard from Tunde, he's giving us his views, but we want to know what your own views are before Odisa would speak a little bit more on the committee. So please, can you vote now? Stephanie, 30 seconds, and then you can take it away and let's see the answer. Okay, so what's the answer? Should the principle of party autonomy be reviewed? So 79%, and now we have many more people. So 79% said no, that, okay. So we don't want mandatory requirements for this. But we have a good 21% that think we should. So it will be very interesting to hear from those who voted that we should, because we already know those who said no, basically on today's side of the ring. I wish we had our debate so we know who's winning. So it will be interesting to hear from those who have said yes. We want to understand why they say yes. Okay, thank you. Stephanie, can we please close the poll? Thank you very much. Olisa, please, can you tell us, just educate us a little bit more on what your committee has been tasked to do, and then we'll take it from there. Thank you.
Thank you very much, Emilia, and thanks, Tunde, for a very brilliant presentation of the issues. And I think I'll adopt all of the arguments that Tunde makes for a policy. So I think we all agree that it's not as if anyone opposes the policy or the inauguration of the committee. The issue is, what is the approach? So I think what brought about the need to inaugurate the committee was, of course, the recent award, the P&IDL Award. And Nigeria had to struggle out of paying almost $10 billion. And then I'm sure they asked themselves, I don't know what happened in government, but I'm sure they would have asked, what went wrong? And even though Tunde says under 1654, P&IDL may not be classified as a Nigerian entity, but the fact is, everything was Nigerian. Everything was wet gas, Nigerian gas, land to be given by Cross River State. So it looked as if all the connecting factors were in Nigeria. So how come it ended up in London? That seemed to have been the impetus for saying is it not time that we look at, what's playing out in the arbitration community? And I don't think it's anything new. I have called for a Nigeria covenant. You, Emilia, at the AAA have the Africa Pledge, and everyone is talking about, how do we involve Nigerians more? So our role is to, and that's why this is important, is to take a holistic picture, get the business community involved in this, discussion, in particular the arbitration community. It's interesting that the mandatory requirements received a negative response from this poll. So that's a good indication about how the committee should approach its work. But I think at the core of what I understand we're supposed to do is, how can we get Nigerians, Africans, more involved? And I take the point that we haven't done well, and that should also be part of the discussion that will engage the committee. If, Emilia, as you say, 7 months to the Supreme Court to decide a case, it takes 20 years here. Who would want to be in Nigeria? Nobody. So it's understood and accepted, and a challenge that we face, that unless we get the enabling environment right, then Nigeria is not going to be an attractive seat unless you compel people, which I think would be contrary to the basic rules. You need party autonomy. So we will be looking at, different steps. And I think, Emilia, you have highlighted them. Some that are essentially private, domestic, to Nigerians, even though the Nigerian company might be owned by non-Nigerians. I would classify it as Nigerian. So should therefore we have a rule or an enabling environment that suggests that Nigeria should be the seat? That will be one. The more difficult approach, I think, for me, speaking for myself, when it comes to like government contracts, we have to be careful about what really is party autonomy. So that's what I'll be putting out. What do we really mean by party autonomy? Because there's a lot of work in arbitration that we have contracts of adhesion, standard contracts where the arbitration clauses or agreements are already written in, and all you need to do is to adhere to them. So can that be said to be party autonomy? So we'll need to redefine, review what exactly is party autonomy. The other concern I think we will grapple with is, because I know that for ICSID, investment arbitration, lots of countries are pulling out. And why are they pulling out? Is there loss of confidence in ICSID? Is that happening? So in spite of the fact that the environment in Nigeria is not world class, but if, for instance, we say that the Nigerian courts would have decided the P&IDL award differently on review by Justice Buba, he granted an injunction. As you recall, it went before the tribunal, and the tribunal had to decide the question of seats. So one of the things we should be looking at is some of the language in our arbitration in ACA is so old. Just this morning, I looked at the 1996 arbitration law in the UK, and I compared it to ours, and I could see a huge difference. In our case, where exactly is the seat? You would see that the tribunal grappled with that question and came to the wrong decision by saying that the seat is in London, when the parties clearly stated the seat, that venue was to be in London. Now, what's venue? What does venue mean? Is venue a place, or is it the seat? So these are questions we need to clarify. So one task that the committee will be engaged with is how to modernize, looking at the model rules, looking at even the 1996 Act of England. How can we, is there space to modernize the language and remove the ambiguities in our ATA without reference to the issue of compulsion or mandatory? Just the fact that I think there's a need that we have to upgrade the ACA. There have been many interesting decisions, and I think Tunde, you yourself criticized the Supreme Court decision, or no, you distinguished the Supreme Court decision in Sona versus not doing. Remember the case? Because there it was people felt it applied to arbitration, but it didn't. It was strictly on litigation. But that case throws a light about what the so-called connecting factors. Why would it be that in a case where a shipment of rice comes from Thailand and the destination is Nigeria, the owners of the vessel are Liberians and reside in Germany? So there are 4 connecting factors, but everything points to Nigeria. So why should Germany, for instance, be the seat of arbitration? Those are difficult questions that the Nigerian courts have dealt with, not on arbitration but litigation, but they have parallels. So we need in our committee to take a lot of opinion, consultation, but bring our arbitral legal structure into a frame that does not exclude, does not offend the international arbitration system, but also takes into account the need for Nigerians to be in the arbitral business. I think that no one can deny. Tunde says that he's not come across cases where purely domestic arbitration, will have seats in the UK. Oh, I've seen so many, particularly in simple badge hire, badge hire. I think this year we had about 6 or 7. And I would say, why would a badge hire 5,000 ton deadweight between One and Port Harcourt, such a short distance, in the case of a dispute, be referenced to London? Maybe it's because the owner of the badge knows that he'll get a better deal, speed and efficiency, which I take. But rather than do that, I think that what we would be saying, and I'm happy that the Chief Justice of Nigeria issued practice directions about how the courts should understand the arbitral process. Because right now, you are quite right today. We just had one, terrible decision from the High Court of Lagos State, a complete misunderstanding of the basic rules. So there's a lot of work that I think the committee needs to do if it will really begin to, attract, make Nigeria be a seat that people want to attend to. But there's the other issue. I don't know whether you agree. I just put it out. That's part of what I think the committee will be grappling with. This whole issue of sovereignty. We had the case where Nigeria has 30 properties under attachment in the UK. And when I read the Eurafric decision, I just wondered, couldn't some of these things, in spite of the fact that we are not attractive for arbitration, but why wasn't, on the basis of sovereignty, Nigeria be seen as the seat? Let me give the example of the production sharing contracts. Someone once told me, I think it was Dorothy Ford, I'm not sure, but I think it was Dorothy, about, people don't want to come to Nigeria because one arbitrator who was in the hotel, got molested at 2 a.m. I said, oh, that's very unfair and unkind to those who came to molest him at that time. But all the multinational companies are able to do business in the creeks under terrible conditions. They're able to do business. In spite, they're not leaving. They're not saying, oh, Nigeria is such a difficult place and therefore we're not going to come here. They're coming. Investors are coming. So why is it that they're able to come, do business, repatriate a lot of profits? Then when it comes to dispute resolution, say, no, it's an unfriendly terrain. I find that a bit of a round robin. They're coming here. MTN was here to do business. And when it then found a dispute that they wanted to go away, and I think Luke and Oyobode were involved. So it's going to be a whole mix of things.
Okay.
A whole mix of things. Yeah,
Okay.
Emilia.
So thank you very much, Olisa, for being open to receiving ideas. And I'm sure you would want attendees and participants and anybody who has an interest in arbitration in Nigeria to freely send in views to the committee. We'll come back to that. I just want to pick up on a couple of things that, you know, the committee must also recognize that this is the 21st century. And, you know, Tunde talked about a laissez-faire system and that move. We have more sophisticated parties because we do have sophisticated lawyers who advise these parties. And so if the Nigerian state, because I think we're all agreed that the purely domestic without public impact or influence is really not a problem. The key question then becomes, should the Nigerian government, through its various agencies and ministries, enjoy additional protection? Why are we protecting the Nigerian state from its failings? So they signed this contract. Nobody put a gun to their heads to sign it. They signed the contracts. And we're not thinking of dispute avoidance. My particular concern is we must comply with things that we sign up to. If we sign a contract, we need to live up to that contract. So if we go back to P&ID, I can't understand for the life of me how you would undertake to provide a resource, wet gas, that you have no control over. And when it became clear to you that you can't provide wet gas, you can always renegotiate your contract. If you have
Emilia, let me come in at that point. That's a very important point to touch upon. And I actually wanted to jump in there because it also answers a question that Mrs. Funke Adekoya asked. Mrs. Funke Adekoya asked, to the extent that the problems of P&ID were arbitration related, there were two problems: lack of internal records and monitoring of government contracts, and also lack of expertise on computation of damages in investment contracts, the discounted cash flow method. She also asks, will a policy that restricts my right to appoint whoever I please as arbitrator not be contrary to constitutional right to freedom of choice and association? But going back to a point she asked about, she made, and which you just made now, Emilia, I wanted to, you know, I happen to stand in a very interesting position because just before P&ID, I had acted as counsel to an international oil company, identity not disclosed for confidentiality reasons, but I had acted as counsel to an IOC in a dispute that involved the same kind of contract that was involved in P&ID. And it was a gas sales contract, just like now. The marked difference between the contracts this IOC entered into, and of course, just like the Nigerian state, it was this IOC that had the duty to supply wet gas, okay? Just like the Nigerian state in the case of P&ID. Now, the difference between the contract this IOC entered into and the one the Nigerian state entered into was that the IOC's contract had two very important clauses. It had a best of effort clause and it had a liquidated damages clause. Now, what that meant was that the IOC was only obliged to supply wet gas on a best of effort basis. So if the gas wasn't there, they were not obliged. Secondly, even if they were found liable for not having exercised best effort, their damages were limited by a liquidated damages clause. Now, I find it difficult to understand how a tribunal could have awarded $6 billion against Nigeria if the Nigerian contract had a best of effort clause and a liquidated damages clause. So this goes back to the point I made about let us deal with the ailment as we deal with the symptom, right? Yeah. Now, we need to develop capacity right from the point of contracting. From the very, you control risk at the very point you begin to draft the contract, because you best of effort clauses and liquidated damages clauses are risk control mechanisms. How well trained are our drafters in public service in risk control and risk management? Then when you even get into dispute, how well trained are they in dispute management, right? And you see, what I don't like about a policy that says Nigeria for Nigerians is that such a policy carries with it the danger that we will cocoon ourselves inside this Berlin Wall, in which developments going on internationally are not being diffused to us. Very recently, you all know how we failed to get a position on the ICC court because our candidate was considered to be somebody who wasn't very familiar with international standards, right? Let's not cocoon ourselves with a policy that says only Nigerians for Nigeria. Let us continue to be plugged into the international system so that we can understand international standards and apply those standards in the way we run our affairs. That's my advice.
Tunde, thank you so very much. I think that is really important. And then I think another example that may impact on all of us is closing our borders, which I still find very ridiculous. But anyway, in the face of Africa Continental Free Trade Area,
yeah,
the whole continent has a market of 2 billion.
Well, can I respond to that, Emilia?
Yes, please, Olisa.
Now, but the borders were now closed. Borders were not, that's a misnomer. Okay. It's true that the government used the wrong term, border closure. What happened was it's border enforcement. Even if you're in the European Union on the Schengen scheme, a Frenchman comes to the United Kingdom to enter, he will show his passport. What Benin Republic was doing was contrary to the ECOWAS protocol. Just to add this very quickly, a lot of the shipments coming were destined to Cotonou as port of final destination. Mm-hmm. Anything going forward is regarded as smuggling under the ECOWAS protocol. That's why we enforced our border by saying you don't bring it. Unfortunately, the government used the wrong term. It should have been border enforcement, not closure.
Okay.
And the only way we can grow. You see, this is a point that we must be nationalistic.
I do not wish for us to digress. This is,
okay,
let's leave it to arbitration. It's nice to just sort of throw out those bits.
Yeah, all right.
And so Olisa said something about ICSID and loss of confidence. And of course, we all know that there's under the UNCITRAL Working Group 3, there is the ISDS review is ongoing. ICSID is been reviewing its rules. We all know that South Africa, I prefer that we draw examples from within the continent, other African countries with whom we share more in common than the US or the UK. And so South Africa, yes, had tried to renounce, or is not very active, let me put it that way, within ICSID. But what we do need to remember is that going back to the courts, and these are things just to throw it out there, is can our courts, the reputation of our courts, are they comparable to the reputation of the South African courts? So that's something to throw out there. The other thing is when we talk about maritime contracts, so the example that Olisa gave about moving a barge from Onne to wherever within the Niger Delta there. The key question is, this is an area where we have loads of standard form contracts, which goes back again to drafting, so most likely a standard form contract may have been used. It's possible to use that without clearly going through and knocking off what is not relevant to the parties. So it goes back to one of the things Tunde just said, this whole idea of expertise, of drafting skills, of understanding how international tribunals are interpreting these contractual provisions and investment provisions, and what do we need? What do we want out of our relationship, our international investment relationships? What do we want? So when we sign up to a BIT, how is that beneficial to us as a nation? Or are we just signing because we need to sign? Nobody says you have to sign any of those things. And I'm aware that Professor Idonije has always been calling that we need to review bilateral investment treaties, which we had signed, the old generation ones. Even the Nigeria-Morocco treaty should be renewed, should be reviewed, because the law is not static. It is developing, and we need to ensure that we grow and move on with the law. I think that then takes us back to what Tunde had said, this whole idea of cocooning ourselves. We're not an island. Even Mauritius is not cocooning itself. We don't want to sort of keep ourselves away from everybody. It's only Nigerians for, Nigeria is only for Nigerians. I think that is very 1960s. It's just not, it just does not resonate. So for the vast majority of us on the call, you all have children who are in schools in different countries in the world. And the world is a global village. But one of the major problems with that global village is that you need to think for yourself. You need to ask yourself, what is in my own interest? How do I engage? So if we continue to have ministers, and I don't know if this is true, where you have lawyers in the ministry and the minister goes off and signs a contract and does photo opportunity and comes back and throws it at the desk of the lawyer, it becomes a problem. So it's not as if we lack legal expertise. I know that Shukbo Shashore was badly flogged by the judge here, but really, if you've practiced in Nigeria, and most of you practice in Nigeria, it is difficult to get documents from Nigerian agencies and Nigerian government departments. You can't find documents. To even get them to pull their witnesses, to pay for them to go to somewhere, it's a problem. And so for me, I think that since the group agrees, I think the vast majority agree that we do need a national policy. Like Tunde has already reminded us, let's not treat the symptoms. Let's uproot what is not working. Let us identify them, be bold, and say these things are not working. So with that summary, Olisa, I know you want to say something. Yeah. Just give me 1 second. Okay. I would be grateful. I think we want to open it up for people to make comments. Right. So that's if you want to speak, if you raise your hand, I think that's the way it's done, Stephanie. We will take a poll before we come to people raising their hands. And what we want you to do, you get 31 minutes maximum 1 minute. And what we want you to do is to give Olisa ideas for his committee. What do you think the committee should focus on? What do you think that the committee should not just attempt doing? We've said, leave party autonomy alone. But what do you think? And I noticed that we do have some people signing in from the UK. As I said, we have people who are also non-Nigerians. I think it's important because you do business, your clients do business in Nigeria. We would want to hear from you as well. Olisa, I'm going to give you 2 minutes and then we have the poll and open it up. Olisa.
No, I was just going to add to the basket of considerations the fact that there is a strong view about I don't want to say this, casually. So let me be very circumspect the way I say it, because if you ask me, do I have proof? I don't have. But there is this silent view that developing nations don't get a fair deal in this so-called international arbitration fora. And let me return to this P&IDL case. The decision was absolutely wrong, the one by the tribunal on seats. Please, everybody should go and look at it. There were 3 issues: venue, seat, and place. And they just mixed up all the issues. So why would I have confidence? Why would I have confidence in spite of all the jaga in our own country? Why would I have confidence to go to a place where I'm not sure? And I've been in many, international tribunals where, in fact, I was in one where there was a partial final award. And I could see that, yes, the Nigerian entity didn't have any, but I was prepared to say, let's give them a chance to put forward that. No, they were shut out. So how do we deal with that problem?
Okay.
I'd like to have advised. How do we deal with that problem?
Okay, great. And so thank you very much, Olisa. Just I have read the P&ID, the award, the dissenting opinion by Bayo Ojo, who is also on the webinar, and the parties accepted. The parties said that London is the seat. So I mean, it's so a seat, venue, place, and all of that. The parties, even in their first court submission, expressly said London was the seat of arbitration. And so, which was why, for me, I didn't even understand why they were now turning around to fight seat. And what are we saying? Are we saying arbitrate in Nigeria so that we can influence the Nigerian courts? Is that what we're saying? How would anybody have confidence in Nigerian arbitration if what we are saying is that why we want Nigeria as seat is so that we can influence the judges, and so we can frustrate people and their disputes by going to the courts? We can't say that. And we need to stop doing that because it isn't working for us. It is not working for us. So many African countries are doing fantastic work. They're moving forward. So it's very infuriating when Nigeria is shooting herself in the foot. It makes no sense. Anyway, don't get me going. Okay, panelists. Okay, no, I want to hear from members. And so if you can think of, if anybody wants to say something, please, Stephanie, just mention somebody, that's fine, but you'll get 1 minute. I do apologize because we have 98 people on this call, so we would want everybody to say something. I think Dorothy wants to say something.
Yes.
Yes, please, Dorothy.
Yes, thank you. Emilia and Tunde and Olisa, I've heard your contributions and it's very good. I support the view that we should not throw away party autonomy, but Olisa's committee has a lot of work to do. And in my personal view, the attraction of Nigeria as a reliable seat is not just with the courts. What about with the arbitrators? If we as arbitrators inherently don't do the right thing, we see black, we call it white, we see black, we call it white. How will we be attractive to whoever, even to Nigerians? We have said now, and I agree with Olisa, I have seen contracts with purely Nigerians and they are choosing the English seat. Today in Nigeria, it's easier for a camel to go through the eye of a needle than for you to successfully enforce an arbitral award. Most of the arbitral awards that are being, that people are trying to enforce in Nigeria are nothing more than a worthless paper. What the investor wants is not the paper. He wants his money because he has won. But I will also talk about what I think creates problem in arbitration. Majority decision and finality of the award. Most arbitrators are playing on that. So what most countries are doing now, and I'll give you an example. The Beijing International Arbitration Commission, just like Olisa's commission. They have reviewed their rules and they have set up an investment arbitration center. I'm speaking next week at an investment oil and gas arbitration that has just been set up in Istanbul. It's on LinkedIn. But let me give you an example of the way Beijing has sought to deal with this problem. I agree with the annulment proceedings that ICSID embarks upon, because honestly, some of these awards, if they were subjected to a review, most of them will be set aside. Arbitrators cannot just decide cases on the basis of their whims and caprices. We must do the right thing. And I'll refer Olisa to Article 46 of the newly established International Investment Arbitration Rules of the Beijing International Court of Arbitration. It provides for an appeal. You see, that is where we arbitrators have taken ourselves. It provides for an appeal against the award. And let me read it. I've just got it. Article 46, appeal against the award. An award may be appealed against in accordance with Appendix E to the rules if the parties have so agreed in writing. We can look at what is happening around the world if the parties have agreed to it in writing. So if you include this kind of phrase, you're not compelling everybody to do it. And that comes to the drafters of the agreement. If the parties, if we include such a clause, and the parties are aware, and they agree to it in writing, that whoever is unhappy with the award, I have done several annulment cases with the ICSID, Emilia, and sometimes the person that is aggrieved files an annulment proceeding immediately, and then the tribunal looks at it. If we find, and they rarely set aside those awards, rarely, exceptionally, but in exceptional cases, they set aside the awards. I think that gives the losing party some comfort that, well, another panel has looked at it. So if we look at things in this light, and when arbitrators know that their award, their decision will be subjected to a review, I think we will think twice. In my opinion, that will be one of the things that we can do to make Nigeria attractive. Thank you
so very much, Dorothy. Thank you. It's always a joy to hear you speak. I'm just going to hand over to Tunde, and I'll give Tunde about maximum 2 minutes. And when I say 2 minutes, I do mean 2 minutes. Tunde, I know that you also, you're in favor of an internal appeal process for awards. And I was wondering if you want to speak, not in the context of ICSID. And for those of you who are not aware, I always love plugging my wonderful sisters and women who do great work in arbitration, and Ufot sits as an ICSID arbitrator, and she's done a couple of these annulment proceedings. So we do have stars out there. And of course, you all know Funke Adekoya, so she's my VP. So there's no, I don't need to announce too many of names. Okay, Tunde, do you want to say something about what your proposals are as it relates to an internal appeal process for awards?
Sure, Emilia, thanks. You see, that proposal, and in a nutshell, what a proposal is this, that you, on an opt-in basis, parties should be free to choose that when they've finished one round of arbitration, the review on the merits of that arbitration award should be conducted by an appellate arbitral panel, a panel to be chosen by in the same way as the first panel was chosen. But so that in a nutshell is the proposal. But the real intention of the proposal is to then say, once you have that kind of process in place, then there should be no further reviews by the courts except on public policy and arbitrability grounds. So the objective, and it's something that I would very much like Ulisa's committee to look into. What motivated that is this. As we all know, the waiting time for an appeal in the Supreme Court is an average of 8 to 12 years. Unless, of course, you are very influential and you can get accelerated. Yes, indeed. And in the Court of Appeal, it's probably 3 to 4 years. So if you get an award, you want to, and somebody applies to set it aside and you can't enforce in the meantime, then you probably won't be able to enforce for a cumulative, maybe 2 plus 4 plus 12 years. That's our reality. That's our current reality. We have a 3-tier process. And unfortunately, we also have a review process that is very, very similar to a review on the merits, because you have what you call misconduct, and we've brought all sorts of things under misconduct, right? Now, so the objective of this proposal is to say, let us limit the extent to which the courts can review arbitral awards to just public policy and arbitrability grounds. Now, of course, to take care of the concerns of those, very much like Dorothy expressed just now, of course, arbitrators can make mistakes. And who wants to live with the finality of those types of mistakes? Well, to cater to the concerns of such people, we then set up a second stage of arbitration where other arbitrators will have a look at what the first arbitrators have done within a period of 2 to 3 months. That's what's in the proposal. Nothing more than a 3-month process. They will not be calling witnesses. They will not be hearing witnesses. They will simply be reviewing the records. And if they come to the conclusion that these arbitrators got it wrong on the records, they will review that award. So there will be a review to comfort people who think there shouldn't be finality where there can be errors. But once that review has taken place, the role of the Nigerian court should be restricted to just public policy and arbitrability, because those are the only types of interests that the state has an interest in.
Great.
Completely agree with you today.
So I'm going to ask Professor Idonije, who does a lot of work in this area or in this field, to say what does he think that Olisa's committee should take into account. When, Prof, you have only 2 minutes, maximum 2 minutes, and then Funke Adekoya would come on board and also say what she thinks the committee should take into consideration. Anybody else who wants to say something, just put your name in the chat, and I would, as long as we have time, because I would want Olisa to get as many comments and views as he possibly can that would aid the committee's work.
Thank you so much, Emilia. I'm grateful.
Thank you, Emilia. Hello.
We can hear you, Prof.
Okay. Thank you, Emilia, and thank you, our Presido, for putting up this platform. And Tunde, well done. Now, I think we should step back a little bit. When you review P&ID, you find that the problems essentially deal with contract negotiation and contract administration. So I will urge the committee to focus on this part, that contract negotiation is not tea party. Especially at the government level, every legal advisor assumes that he knows everything about contract negotiation. So a team will be set up, and you are talking about people who know nothing about the subject matter. So we should spend more time on contract negotiation. And if we are going to have a clause on arbitration, take advantage of the principle of party autonomy. There are many rights given to the parties under the Act. Secondly, like Emilia said, contract administration. We cannot sign a contract and go to bed. We cannot assume that doing business is like running a government office. So if we focus on contract negotiation, we're talking about standard form contract. Now, you must be competent to review that contract to know clauses there that are not suitable for your use. So get competent people. I always tell them in government that you are a legal advisor does not mean that you know everything. So get those from outside to assist you to negotiate. After negotiation, have a checklist on administration. Thereafter, have a committee on dispute prevention. Dispute prevention if a dispute arises, take all necessary steps to ensure that there's usually a clause on amicable settlement. Ensure that you exhaust everything before that dispute escalates to a real dispute that will take you to arbitration or litigation. So, in summary, let us focus on how government negotiate contracts. They should ensure that those competent to negotiate are those negotiating. And if we commit to the contract and we sign up, we should comply. If we cannot sign up, let's renegotiate. Thank you very much.
Thank you very much, Prof. Olisa, you got that, yeah? So, Mrs. Adekoya. And after Mrs. Adekoya, there is Joseph Siyaidon. Forgive me if I pronounced your name wrong. And then after Joseph, Anu Ogunro.
Good morning, everybody. Thank you to OAL for this platform and for the contribution so far. I have 2 minutes. I have 4 points. So that means I have 30 seconds for each point. First point, contract monitoring and negotiation. I suggest that the committee looks at what happened in Peru as a start-off point. And if the view is to have that type of body that Peru used when they started to have so many international arbitrations, set it up in the NIPC. Second,
okay.
There is a bill that has been pending before the National Assembly to amend our Arbitration and Conciliation Act. I suggest that the committee pushes for those amendments so that we have a modern UNCITRAL-based Arbitration Act in place, which will also attract foreign investment and make us more attractive as a seat. Point 3, I suggest that the committee looks at how we can have judicial support for the arbitration process by ensuring that when enforcement proceedings go to court, they are speedily determined. The main position now is that arbitration is the first step before litigation. So if there's a protocol or a practice direction that says that if you are challenging an award, you either provide a bank guarantee for the value of the award, or you pay the award into an interest-bearing account until the set-aside proceedings, the enforcement proceedings are concluded. It might fast-track. You could also suggest that enforcement setting aside proceedings should be on a fast track before a commercial court. Finally, government support for the arbitration community. As long as we have governments that are negotiating contracts and bringing in foreign law firms, and those foreign law firms then approach Nigerian law firms to give them Nigerian law advice on the contracts that they wish to enter into, we are subjugating ourselves. The government should appoint Nigerian law firms for negotiation of all contracts in which the federal government and state governments are involved. And if, as they say, which I dispute, we do not have the expertise, then they should tell us to indicate when we are bidding for that work, which foreign law firms we are going to associate with. That will also enhance our capacity within the international legal community. Finally, as point 4B, the government should support the arbitration community by ensuring that there is adequate exposure to training and knowledge of the legal state council in ministries of justice, state and federal, so that they become fully conversant with arbitration practices and procedures. I've sat as an arbitrator involving Grenada. They were represented by their state council as well as external counsel. They were fantastic. I sat as an arbitrator in investment proceedings involving Tanzania. They weren't that great. We need to enhance our skills for our state council in arbitration so that they themselves can defend these proceedings. Thank you.
Thank you very much, Mrs. A. And maybe Nigeria should also speak with the Ministry of Justice in Kenya. it is their state council that have won, I think 1 or 2 with the support of external counsel arbitrations. And so that would, that's something for them to also explore and think about. And then the other African state that is doing a lot in this space, equipping their state lawyers, is Egypt. And just like Mrs. Adekoya said about Peru, when you have loads of arbitrations against you, then you do need to think carefully, how do you stem this tide? And so what is the learning from all of the disputes that we're having against us? And that's part of what triggered Egypt's reform process. And so there are lots of examples that we can be looking at. Let's stop looking at America and the UK, that we're completely different jurisdictions. Joseph, 2 minutes, please.
How many questions?
You're on, yeah, please.
Yes, thank you very much for this privilege to address this esteemed group. Haven't had the privilege of practicing for a while in Dubai. I feel myself really privileged to speak to this group. Now, first of all, I want to address the issue of corruption. It is important that this committee looks at how to address the issue of corruption. Is very, very vital. Now, I'm aware that part of the reasons why Nigeria does not have an arbitration legislation yet, as it's been proposed, that is still pending, is corruption. I have an inside information. I shouldn't be declaring this, but I have an inside information that some power blocks in the National Assembly requested for some funds or some of gratification in the passage of that bill. And because that was not given, that is being held. Secondly, Nigeria does not have some policy guidelines that are clear enough. For instance, the issue of third-party funding. Now, third-party funding is said to be one of the incentive that attracts arbitration to a jurisdiction. Now, for Nigeria, we don't have third-party funding or not. Now, a case was filed recently, P&I against Nigeria. Tunde said, they submitted an opinion that third-party funding is not recognized in Nigeria, that it is third-party and maintenance. So there is no clarity as to that. Then thirdly, transparency and due process. Now, for most of the projects going on in Nigeria, like the Niger Bridge and all the rail projects, there are no dispute adjudication and resolution boards. But if you check the contract, you will see that there's provision for this. And so Nigeria cannot involve, because what will make Nigerians get involved in those boards are not there. So they jettison some part of the contract and then leave it. And then when there's problem, they will expect Nigerian lawyers to. Thank you for the privilege.
Thank you very, very much, Joseph. Those are very important points. Third-party funding is important. That's the future, really, where we are. And I think we need clarity with policy guidelines. And Olisa, somebody had already asked in the Q&A whether there's a time frame for this project and when we're going to see a white paper. So just to add that. Anu? Are you still there? Ogunro? Is there anybody else that wants to say so? Oh, great. Anu, 2 minutes, please. We can't hear you.
Okay, good morning, and thank you for this opportunity. I would just want to say that while we should respect party autonomy, we should also consider certain instances where all the evidence, the parties, and even the law that guides the contract are in Nigeria. In such a situation, the committee may consider making it mandatory that the seat of arbitration should be in Nigeria. And we know that where we have the seat of arbitration also determines and affects the laws that guides the arbitral process itself. So we have to work on our arbitration rules, as has been suggested earlier. We have to work on our arbitration rules in such a way that it enhances arbitration and gives some form of confidence to parties to be able to have the arbitration conducted in Nigeria. I would also want to add that the committee should consider the issue of corruption. perhaps we should have a code of conduct for arbitrators, which the arbitrators will subscribe to, that if they are going to adjudicate in court over a dispute, there should be a code of conduct. I know that in other jurisdictions like the UK, we have this issue of where there has been a manifest disregard of the law and facts, that manifest disregard of law and facts that affect the particular dispute. Such an award will be set aside. We have limited situations in which the court can intervene in arbitral awards. Mostly it's under what we call misconduct, and then that has been a lot of definitions and issues that come under misconduct. However, because facts or decision of arbitrators on facts, it seems to be something that the court cannot intervene, so to say. We need a situation whereby we have a rule that where the arbitrators have manifestly disregarded the law and the facts from the records, where it could be seen that, oh, there has been a manifest disregard of the law and the facts.
Counting down. So yes, 9.
Thank you. In such situations, 8. That award should be set aside, and 7. Also code of conduct to affect arbitrators, whereby they would be not necessarily punished, but maybe the word punished used for such situations. Thank you.
Perfect. Thank you so very much, Anu. Hamid Abdul Karim.
Can you hear me?
Yes, we can hear you, please.
Thank you very much, Dr. Emilia, for Dr. Nyema, for the opportunity. Just a very quick comment. We've seen a number of reactions from some African countries, South Africa popularly, withdrawing from the ICSID system because of one or two unfavorable awards. And I just wanted to point out, when one looks at some analysis that scholars have done, you find that actually states actually tend to have the upper edge in terms of their success rates in these types of arbitrations. A lot of the arbitrations are actually dismissed for jurisdictional reasons. Quite famously, Nigeria prevailed last week in an ICSID arbitration. So it's important, I would suggest, for the committee's work that we don't start from the perception that, look, it's all bad because states tend to lose. Yes, states tend to lose, but states also tend to win a whole lot. I'll find means to circulate some of that analysis that has shown that actually states do well in ICSID arbitration, and generally, at least as far as is publicly known, in investment arbitration. Thank you very much.
Thank you very much, Hamid, for that contribution. I suppose it's really not just how many disputes states win. It's the volume, the volume of damages that very fragile states may be saddled with. For me, I think that, you remember I had talked about the work that is ongoing at the UNCITRAL, that I know that people from NIPC also attend and participate in. Nigeria is part of the international community, and it's a member of ICSID and should engage. Nigeria is also a member of UNCITRAL. I think that for me, those are the proper fora to engage with the work that is ongoing, not just because of Nigeria, but we can contribute to the jurisprudence in this field. So there's absolutely no point. It's not, it's been very evident, we have capable Nigerians who are very versed in this field of the law. So there's absolutely no reason why we cannot have proper people who have expertise listed on ICSID as arbitrators from Nigeria that other states can appoint, and to represent Nigeria at ICSID, at UNCITRAL, at these various working groups. There's absolutely no reason. You can't have experts all over the place within Nigeria. So I can understand when people like myself are excluded, I can understand that, but they're experts within Nigeria. So we cannot continue to disregard the experts that we have and opt for mediocrity for whatever reason. That is a disservice to the nation. And Olisa, that's something that your committee needs to look into as well. I have a concern that hasn't been raised, and that's something somebody mentioned, corruption, as part of the remit of your committee. So I was just wondering what the interface of your committee would be with ICPC and EFCC and all the other 1 million and other one agencies that investigate corruption, that do this, that do that. And the second thing, I'm very, very concerned that we do not do any forensic investigation. When something goes wrong, we need to go back, trace the steps back and understand how did we get here. I haven't heard Malami, the Attorney General, say, I have launched an investigation so that we know exactly internally within his ministry exactly what went wrong. How did we get here? Nobody has told us how much we have paid lawyers and the flights to go to the US. We have lawyers all over in the US, in the UK, different law firms in the UK have been engaged in P&ID. So the proper cost, nobody has told us how much we have spent just fighting this. And nobody is being held to account. I'm not talking about vindictively, but we need to use all of this, to learn so that it doesn't happen again. So I've just been told in the chat that Kenya, their state lawyers have won 2 investment arbitration. And if you know anything about investment arbitration, it's not easy. So you do need to know what you're talking about. And so training of government lawyers is really important. You don't throw somebody who's been doing petty theft at magistrate court and then the next thing they're the ones advising on an investment dispute. I mean, that is in itself a crime. So we do need, it is very serious, because if we recognize that we have Nigerians who cannot pay school fees, which is why they will not go to university because parents cannot afford it. We have Nigerian women who carry stuff on their heads, selling tomato and all of that to pay their children's school fees, then it is a crime. If we're being forced to cough out 9.6 billion. And I hope that the Nigerian lawyers will not take the glory for P&ID. We need to be thanking the judges who were able to see through the maze. And we must thank Magu and the EFCC. These are my personal opinion, but I feel quite strongly about these things. It's not partisan. I'm really not a politician. I'm not interested in that. But we need to think of the common man on the street and the impact of the decisions that we take on them. It is very important. Ultimately, that's what life is all about. Anyway, that's my 5-minute rant. Is there anybody else who wants to say something? If not, I'm going to come back to Olisa, so that I will give Tunde the last word, but I'm going to come back to Olisa because we're almost out of time. I think it's been engaging and been very interesting. Olisa, so response, have you got, sorry, I've just been reminded that we have 2 more polls left. Oh, Shola wants to say something. Sorry, I didn't see your hand. Shola, please say something, then we shall have the poll and Olisa will say something. 2 minutes, please.
Extend it. She can extend it.
Shola, please go on.
Okay, on mute. Okay, so just 30 seconds. I mean, this has been very, very interesting. Thank you very much. I just want to ask, I mean, we've talked about all our experts and how well we're doing. I have put it in the Q&A, but I would like to ask if the committee can be expanded so that all these, our experts, home and abroad, can be a part of the committee, not just sending things to the committee, but please can the committee be expanded, so that they can actually be part of the committee. That's just a little one I want to add now. If there's anything that.
Thank you so very, very much. Thank you.
Thank you.
So, Olisa.
Yes, thanks. I mean, this started as me and my good friend Tunde going to debate the pros and cons until I got appointed. So I think it's, you know, a good omen that this happened, because I've learned a tremendous deal of information that I can see will be, you know, very beneficial to the work we're going to do. And on the question asked by the last Q&A person, obviously it does make sense to have very close proximity to the arbitration community. It also does make a lot of sense if I'm able to propose to the Attorney General that we need to expand the committee to bring on board a lot of the ideas we heard. You know, I think that we should be looking at in absorbing, you know, as many as the Attorney General can afford to absorb, because it will enrich the quality of our, you know, final product. So yes, I can guarantee that I will put that across. I will make a transcript of this discussion. Indeed, the senior special assistant to the minister, because he was to come on to make a short goodwill, but he couldn't. But she told me that they'll be very happy to have a package of what we've discussed, transcript, and Stephanie, we can have the recording so they can have a look at it and see how rich. You know, I'm you know, overwhelmed by the richness of, you know, the debates that have come from everybody, and I would do my best to ensure that the views of the, you know, and I can see that on this webinar are the best in Nigeria, the best. I mean, the best, very best have been here, and Funke, Dorothy, of course, our guy Tunde. All of what you've said aids the work. It makes it simpler. Things I didn't even think of, I've heard today. So I'm very grateful that I've had this chance to learn, to shift, you know, some of my, you know, strong views a bit. Why Emilia? A bit, but I'm still very strong on one. Or let me just say what I'm strong on. I'm strong on mandatory statutory intervention, because I've seen that used across the world. I've seen it in South Africa, China, India, a couple of countries in Latin America, and even in the 1996 Act, it's there. It's there. I think Section 4 refers to parts where the party autonomy applies, and then to parts where state intervention is. So it may be that one needs to fine tune it, but I still think that if we want to promote Nigeria, but in the context of the soft law that Tunde, you know, referred to, and indeed creating an enabling environment, that is so crucial. So thanks very much for, you know, all the, you know.
Thank you very, very much, Olisa. That's very gracious. Thank you. Thank you. Tunde.
Yeah, Emilia, thank you very much. Olisa, thanks so much as well. I'm very happy. Myself, just like you expressed, Olisa, I'm very happy that this discussion has produced a very robust, you know, very robust discussions around the issue. And we can see it's a very multidisciplinary issue. You need to consult very widely.
Yeah.
If you are able to expand the membership of the committee, that would be ideal. But it's obvious that the problems are very multifaceted. Mm-hmm. and that your work is you've got your work cut out for you, to use that cliche. I want to just advise on comparisons. When you talk about South Africa, yes, so South Africa, the jury is still out as to whether South Africa has been successful in the attitude it took to its BITs. But if investors are still investing in South Africa, notwithstanding that South Africa said, come to our courts to resolve your investment issues, then just look at the rule of law index and see where South Africa's judiciary stands and where Nigeria's judiciary stands in comparison to it. So let's not just quote other countries. Let's look at all the facets of the issue. South Africa is way ahead of Nigeria on the rule of law index, whether it has to do with corruption or it has to do with civil justice and all whatnot. So I would say let's take note of that. But I think it's been a very rewarding discussion, and I want to thank Olisa and Emilia, as well as everybody who's contributed to this discussion today. It's been very rewarding for me as well. Thank you very much.
And so it's left for me to say a massive thank you to Presido and Olisa Agbakoba Legal, to say thank you for inviting me to moderate the session. And thank you very much to Tunde. I think it ended up working out in our favor that we didn't have a straightforward debate sort of thing, but we were able to unpack and engage with various issues. And thank you so very much. At the height of the seminar, we had 100 participants. That's huge. And I think that goes to the interest that the topic elicits. So to say a massive thank you to all those who participated. Thank you for those who made their views known. Thank you for those who have helped us understand the issues involved a little bit better. And thank you to Olisa and all the various members of the committee who we were sure we've been guaranteed that hopefully they would take on board. They would listen to some of the things we have to say as well. So thank you. And then we are on the dot of 12. So I teach and I'm very time conscious. So I'm very pleased. I think we should forget the poll.
Yes. Okay.
Because we have a clear idea of where people on the call, where they're leaning towards. So thank you very much. And I can now say that the webinar has come to an end. Thank you for attending.
Thank you. Thank you.